Number 70, matter of Lemma versus Nassau County Police Officer Indemnification Board. Good afternoon, Counsel.
Good afternoon. May it please the Court. My name is Mitchell Garbert, and I represent the appellant, Nicholas Lemma. The statute under question
So, Counsel,
here,
what does the word proper mean in 50L?
the word proper, I would contend, Your Honor, relates to the scope of employment and not the actual duties itself. I think that
Okay, but what does the word proper mean? Let's assume you're right. What does it mean, proper?
the dictionary definition would be correct or appropriate. But I think that the dictionary definition in the context of the analysis of
What
the
does the word scope mean?
scope means that in the context of an indemnification statute, that the officer is performing his or her duties as expected of a police officer. In other words, in the furtherance of the role of a police officer, which I would submit, Your Honor, clearly Mr. Lemma was doing here. He was investigating a robbery. Now, while clearly...
So if they're interchangeable and they're the same, why have both?
I'm sorry?
If they're interchangeable, they mean the exact same thing, which I think is what your argument is, why have both of these phrases?
Well,
In the statute, what's the point of the redundancy?
It's unclear. The appellate division determined that it was inconclusive. They found here that there was ambiguity in the statute. So I think that under the circumstances, when you consider the legislative history, which clearly both the bill sponsors as well as the colloquy that took place between the members of the Senate, which is part of the record here, the intent was to cover not only imperfect conduct, but unique amongst these type of representation statutes. The intent was to cover and to indemnify any judgment, including punitive damages.
But wasn't the legislative history really that the purpose was to combat a chilling effect on police actions when they were properly discharging their duties? In other words, the idea that even though they were doing what they were properly supposed to do, it's possible that a jury somewhere might find to the contrary, and so the legislature didn't want to discourage police officers from going out and doing what they thought was right, not to necessarily cover intentional wrongful conduct.
Well, that view, while it's been expressed, and there was some colloquy about that in the bill jacket, that undermines the role of the courts in considering a judgment for punitive damages. It eliminates the check that the trial court would have in determining whether or not conduct should properly stand as punitive. And that very small colloquy within the legislative history, I think, is superseded by the actual debate in the Senate as well as the bill sponsors' discussion, where he was asked specifically by one of his colleagues during the debate whether or not it covered reckless conduct, and he said it did. And the bill sponsor even went so far as to say that that was unprecedented in these representation statutes. And that's all part of the record that's been presented to this court.
So can I ask you about the Superior Officers Association, though?
Well,
Members of the force, obviously, they're high-level officers, and I thought their own statement is that the bill doesn't provide blanket immunity, so that a disregard for a consequence will result. The bill contains important safeguards against police officers abusing their authority. No action or omission occurring outside an officer's proper performance of duty will be indemnified.
I would suggest that that letter was submitted after the bill was actually voted by the legislature while it was awaiting signature by the executive. And it's during that period of time, and I think that I addressed that in my reply brief, that period of time doesn't accurately portray what the intent of the law was. When you consider the legislative history, which is to provide for punitive damages, textbook definition.
Counsel, isn't that really what they're saying is you can be acting within the proper scope of your duties? The language is, go to a jury for whatever reason comes back with a verdict, then there may be a check on it, but you still get indemnification. The thing that strikes me as so different in this case is not that you're waiting for that jury verdict or not. Here you're not arguing about what was said in the deposition and what his statements are and what his conduct was. And I don't think there's any argument if you have a rational sense of what proper is. It's difficult to see how that would fit within the definition.
Well, the definition, though, it really relates to this court adhering to a prior decision of the court, and that's the Sakel-Collar case, because...
But that didn't have the word proper. That statute didn't have the word proper, and if we view them exactly the same, then aren't we reading out of the statute that word that the legislature clearly put in there?
Well, I think by analogy, one of the things that the Sakel court hinged upon was the fact that the statute covered criminal defense, and the court indicated that the scope of the coverage was intended to cover that type of conduct. So if you compare the scope of coverage in Sakel to the scope of coverage here for punitive damages, or intentional conduct for that matter, I think that Sakel-Collar is controlling in this case.
So, counsel, so at bottom, is it your argument that if the board finds that the subject of the inquiry intentionally failed to reveal that a jailed suspect could not have possibly committed this crime, that the board has no discretion in making the decision it's called upon to make?
The board would have discretion if they were properly instructed. I think that the record is clear that the board was never instructed as to what proper means. It's not in the statute, and it's never been defined. That part is not disputed in this matter.
So you're saying there's no discretion there?
The board would have discretion, assuming that they had the criteria to make that decision in the first place, and here they didn't.
I thought your position is that scope and proper duties, scope of employment and proper duties are exactly the same.
Not exactly the same, Your Honor, but under the context of the case, those phrases are interchangeable. And that interpretation of being interchangeable is the only interpretation which gives meaning to the legislative intent. And
You say that the statute is ambiguous, right? So if it's ambiguous, aren't we supposed to look at whether the board's interpretation was irrational?
Yes, of course.
So you say it's irrational. There's no reasonable way of reading this statute the way...
No, if the board was properly charged, if they were given the definition, then they would have had the discretion by a three-person vote. But here, the record is clear that not only were they not instructed on what the definition of 50L is, but in fact, as the record makes clear, in other cases involving conduct as wrongful or even more egregious than the conduct here, the board acted differently. And
what is, in your opinion, the source of the correct definition?
The proper discharge pertains to acting as a police officer acts within the scope of employment.
Yes, where is that definition? What's the source of that?
I think that the Sagal-Kotler case makes clear that those definitions, this court, in analyzing comparable representation statutes, has said that it's always been considered interchangeable. There's never been an instance where it hasn't. And lastly, I see my time is up, but in terms of the limitation, The court in Sagel-Kotler said, quite specifically, had the legislature intended to limit coverage to correct or appropriate conduct, they would have done what the statute does in 50K pertaining to representation of New York City employees. It would say specifically that the coverage was limited if the person was found to have engaged in conduct that was in violation of the employer's rules. Here, in the absence of that, given the legislative history, given the coverage, which is unprecedented in representation statutes, the county should have covered my client. Thank you.
Thank you, counsel. Counsel?
Good afternoon, Bob Vanderweg for the respondent county. The county position is rather simple, actually. This is an Article 78 proceeding. We have a determination by a panel set up by the General Municipal Law. It's an administrative proceeding. When the court reviews that, and the court obviously has and should review it, if there's a rational basis for the determination, it remains, even if we disagree with it. In this particular...
Counsel, let me ask you a question. As I understand your briefing, you maintain that the statute says that the proper discharge and scope shall be determined by the majority vote of a panel, correct?
And that's the
So,
statute.
okay, yes, all right. So is it your position that what any respective panel, whoever's on the panel at any respective time, their view of what is the proper discharge or the scope may change, even if the facts are the same?
Unless when looking at the facts, the judge determines that there's no rational basis to come to that conclusion, then just like any other review of an Article 78.
How about if the act itself could be considered punitive damages, then you would say it would be covered by the statute. Is that correct? So if it was an act, let me just finish, an
Yes.
act with malice, an intentional act, that would be covered by the statute, wouldn't it?
Yes, I believe it
All right,
would,
so
but
let me just go through the logic of this. So if this detective intentionally failed to report the alibi that would support a finding of punitive damages, we'd have to say yes to that if he intentionally did it, because it would be an act taken with malice. I thought he testified that...
okay, maybe I'm not following your...
Well,
question.
follow me, stay with me on it, all right? Because I want to know is if he intentionally did this, and there's no proof in the record that I saw that said he intentionally did it, that would support a finding of punitive damages. Punitive damages are covered by the statute, so that would then mean that he would be covered for an intentional act, but not for an act where there's no proof of intent.
May I disagree with your premise,
Sure.
though,
Go ahead.
when you said that there's no evidence in the record that he intentionally acted? I think
The only
there
thing I
is.
saw, I don't know it probably as well as you, I'm sure I don't. The only thing I saw was, I guess he testified and they asked him that question directly, didn't they?
Correct.
Yeah.
And he said that there was a number of questions, and he said that he just let the chips fall where they may. Then
That's true.
he was further questioned as to, because remember, there was a typographical error in the file. So anyone else looking at the file for a period of time would not know that this particular defendant was in jail at that time because the date of the robbery was in error. And he was asked at that time, because he said, well, I figured that they'd pick it up in arraignment and what have you, and the
Right.
plaintiff's
What I
attorney-
have is on the record at page 627, he was asked whether he intentionally failed to report his discovery, and he responded in the negative.
But the evidence is otherwise, including his own deposition, and in fact,
So
at that particular time...
your argument then is, let me just go through it, that
Yes.
he did intentionally fail to report this.
Yes.
Is that correct?
Yes.
So that would be an intentional wrongdoing, and you would argue malice, and isn't that covered by punitive damages?
No. Well, it's punitive damages, but it's not the proper exercise of his duties, and it's not covered under the statute.
Can you give us an example of conduct that would qualify for reimbursement for punitive that would qualify for punitive damages, but would also be in the proper discharge of duty.
It's very difficult, but as one of your colleagues indicated, this is coming out at a time before a trial. I deal with a lot of 1983 cases and a lot of appeals. There are, unfortunately, a number of situations where juries, for whatever reason, come back and find punitive damages. We believe they're wrong. We may appeal it. Then again, we may settle it, what have you. It happens. But
So you're
that
talking about
but
situations
the
where you
intent-
disagree with the jury? You're essentially talking about situations where you disagree with a jury verdict. They give punitive damages, but you don't think punitive damages were warranted.
Well, and also there could be a situation where we were disputing that it's intentional conduct and representing the
Is there any
defendant
language in
during
the
trial.
statute that you can point to that supports that?
Do I have any points?
Language in the statute that supports your theory,
That punitive damages,
that you can be both proper and punitive? Judge Stein's question, give us
I
an
can't
example.
find anything in the statute the statute's a very simple statute. It's right before you.
I thought what your position was, that you say we only look at the plain language. The plain language has the word proper. That word means something in particular, and that works against the plaintiff in this case. And then you say alternatively, if it's either ambiguous or the court wishes to look at legislative history to show how it supports the plain language, the legislative history shows exactly what my colleagues on the bench are asking you about, which is your argument that the legislative history shows that there was a concern that even if locally the board had decided the officer's conduct fit within the statute, that nevertheless they might be subject to punitive damages, and that the legislature had decided that even under those circumstances, the county would be liable.
First of all, I disagree with your conclusion as to legislative intent. I believe we completely answer the argument of the appellant that the legislature intended some sort of blanket immunity. Quite the opposite. Number one.
Oh, no, that's not what I'm saying.
Okay, I'm
No,
misunderstanding.
My point was, I thought you were arguing in your briefs as an alternative position in terms of the legislative history, that what the legislative history is showing, that you're maintaining local control, that is, the board decides what is proper conduct in any particular case, but also recognizing that even if the board, what Judge Stein says, you all might decide differently than a jury would, that you decide, or the board decides something is proper, the majority of the board, but nevertheless, if it ends up getting to a verdict and punitive damages are imposed, that's where the legislature decided, nevertheless, the county will be liable for those damages.
No,
I'm
I
not talking
think-
about blanket immunity.
No, I think to the extent that we're looking at intent, and of course, we take the position it's clear, there's no reason legally to look for intent. Otherwise, you can pull out one senator's and one assemblyman's comment and what have you. It's clear and what have you. There are situations in which pre-trial and what have you, the conduct is such that we believe, let's say county attorney, and the panel itself after hearing believes that it could be a situation where it might lead to a finding of intentional conduct. But this case is so egregious, where a person remains in jail for 4 months, and the police officer says, yeah, I knew about it and what have you, I found out, but I didn't do anything about it, let the chips fall where they may. And when even questioned as to, he said, well, basically he's saying, well, maybe they'll find it out later. And then it's pointed out that they won't find it out later because the date of the
Can I ask you,
arrest
since
is...
your argument has been that the board has been legislatively authorized to determine case by case what is
Yes.
proper conduct, how is an officer to know in advance?
Well,
I want you to respond to their argument in the reply brief about the vagueness of the statute.
you know, if and first, the legislature has not taken upon itself to give a definition of things to the panels that they set up, and I think for obvious reasons, because they want to give the greatest latitude they can to this panel to hear what is going on and make a determination, probably for the benefit of an officer. But in this particular case, it is so egregious and it needs no definition or explanation quite frankly, if they came back and said, this is proper discharge of the duties, I think we'd be shocked.
So is so egregious your answer to the panel here really couldn't articulate what standard they were applying or what they were doing when they're asked about it? Is that how you
Yes,
respond
I
to that
think so.
argument?
And when examined, certainly Commissioner Mulvey, the police commissioner for part of this time, and Kreitman and what have you, Ryan has been around for a long time, an attorney, you know, they used their common sense. They'd be, you know, anyone would be shocked if they said, well, you know, you have to make a determination whether it's the proper discharge of the duty. This police officer has indicated that, well, he knew that he couldn't possibly have committed the crime, but I'm going to let him sit in jail for the next 4 months, and maybe somebody will find out about it. And then he says nothing for 4 years or so. The 1983 action starts, and 20 minutes before his deposition, he says, by the way, I did know about that. That's the
Thank you,
county's
counsel.
position. Thank you.
Counsel, I took the liberty of reserving 2 minutes.
Yes.
Do you care to
Thank you, Your Honor.
exercise that option?
The standard is not whether the conduct was egregious. The standard is whether or not he acted consistent with the statute in the proper discharge.
Well, the officer's position now, I thought in your briefing, was that he just forgot. It wasn't. It's a misinterpretation of his deposition
Well,
statements, correct? His position now isn't, I intentionally chose not to reveal this.
That's exactly correct. And
But the board could hold against him on that, right?
they shouldn't. The
But
elephant...
they could. You're
they-
not saying it's beyond their authority to do so, are you?
Well, it's beyond their authority when they're not properly charged. I mean, the standard, Your Honor, is not egregiousness.
No, but this is a factual finding. I'm not talking about whether or not it's proper or so forth. This question about whether or not, as counsel got up and argued, that he knew and he specifically chose not to inform anyone versus his position that he takes, which is, no, you're misreading my statements or misunderstanding them. I forgot. That's his position now. What I'm saying is the board could read this record, decide on what he said in the deposition, observe his testimony, and decide they disagree, correct?
They could decide to disagree, but all that would mean is that they found that he acted wrongfully. But the egregiousness standard, which was discussed, that leads to the results that have taken place. The record, and it's in my reply brief, shows how the same board chose to represent and indemnify somebody who not only testified improperly and perjured himself in the grand jury, but took a criminal plea to perjury. So that conduct, if you accept the county's definition of proper, perjuring yourself in the grand jury about the recovery of a
So, counsel,
firearm.
when you said they could find he acted wrongfully, but you're saying it doesn't necessarily rise to what the statute means by proper?
I would say that perjuring oneself in the grand jury is never proper. It's the epitome.
No. Please, I'm talking about this officer. I'm talking about the case in front of us.
I'm sorry, could you repeat the
Yes,
question,
because you
please?
said before, when I asked you, you said, well, yes, the board could find that he acted wrongfully. So then my question was, your position is that having found that he acted wrongfully,
Does not
they couldn't then decide, so that doesn't satisfy the statutory
No.
standard of proper?
No, not
Okay,
under...
so how's wrongfully and proper, how
Not-
do you harmonize
Not
that?
under the intent of the statute, because the intent of the statute clearly is to indemnify for wrongful conduct. That's what the legislative history said. That's how the county's been practicing the application of the statute, and I submit to the court that's the way that this court should analyze it as well. Thank you.
Thank you, counsel.